Okay, we left off just before the break, having looked at these aspects of deeds, and we're down to this last one, recording. Let me tell you about recording and recording acts, why we have them, what they do. A deed received from a grantor does not need to be recorded in order for the conveyance to be effective. The effectiveness of the conveyance really has nothing to do with recording the deed. The purpose of recording the deed is just to let the rest of the world know that you own Blackacre, that you own Blackacre, and that if they try to buy it, they have notice of your claim. Let me explain to you what the problem is and why we need these notice statutes and how they work. The problem is as follows. If you have no notice statutes, and before there were notice statutes, what would happen is that a person owns Blackacre and the person decides to sell it, and so they sell Blackacre to Joe. And they sell Blackacre to Joe, and they hand Joe the deed. And meanwhile, of course, they've got a little bit of time to move off the land. Joe just got the deed today. So these people, let's say, have got, a month or something to get their stuff off the land. Well, during that period, along comes Mary, a second buyer, and the owner, grantor, sells it to Mary also and gets another $100,000 from Mary. Well, Mary doesn't know that Joe exists, who's the first buyer. So Mary doesn't know that Joe exists. And so Mary gives the grantor another $100,000. And by the time all of this comes to light, the grantor has taken both of the $100,000s and left the country. And now Joe and Mary are left to fight over the ownership of Blackacre. And the question then becomes, well, who owns Blackacre, Joe or Mary? The common law rule was that Mary was the victim, because the grantor in principle had nothing more to convey after conveying it to Joe, and so therefore Mary got nothing. Mary is out of $100,000, and Joe gets Blackacre, and poor Mary is a victim. So, bad situation. What rules, what policies do you create to prevent that from happening? Well, if we create a recording system and we say to Joe, instead of me calling them Joe and Mary, let me just call them buyer number 1 and buyer number 2. Okay? So buyer number 2 ended up being the victim because buyer number 2 didn't know anything about buyer number 1, gave the grantor $100,000, and the grantor left with money from both people. So how can we protect buyer number 2? That's who's got the problem. And the way we protect buyer number 2 is we create a statute, and the statute says, look, buyer number 1, if you buy this land from the grantor, that your purchase of this land, buyer number 1, your ownership, your deed, is going to be void against buyer number 2. It's going to be void against buyer number 2 unless you gave buyer number 2 some notice that you owned it. And you can give buyer number 2 notice, first of all, by being there, occupying the land, of course. Secondly, you can give buyer number 2 notice by recording it at a central recording place. And so if you don't record it, unless buyer number two, unless you're living on it, well, buyer number two doesn't have any notice. Even if you're living on it, you need a rule that says a buyer number, whoever's going to buy it needs to go out there and look. And if they have to go out there and look and see that buyer number two is now there and not the grantor, that would give them notice. Well, the recording statutes may or may not require buyer number two to go out and look. But all of the recording statutes say, buyer number one, if you do not record your deed and thereby give buyer number two notice that your deed is void against this buyer number two. And that's how the basic idea behind the recording statutes. Now, of course, jurisdictions had various variations on the recording statutes, and let me tell you what these variations are. Some jurisdictions say that if buyer number two buys without notice of buyer number one, it says the buyer number, let's back up. Some jurisdictions say buyer number one's deed is void against buyer number two unless buyer two had notice. Now we'll talk in just a minute about the ways in which buyer two might get notice. So let's come back to that, because that's where one of the complications comes in. So buyer one, your deed is void against buyer two unless buyer two had notice. Now, of course, buyer two needs to be a purchaser. They need to part with some money, otherwise they don't have a real loss. If the grantor tried to donate it to buyer number two, two would get nothing. But if two is a purchaser, in that they had to part with some money to get whatever they're getting, if they had to part with some money, and if the buyer one's deed is void against buyer two, if buyer two did not have notice and buyer two is a purchaser. So some jurisdictions, these are the pure notice jurisdictions, they say buyer one's deed is void against a subsequent purchaser with no notice. Buyer one's deed is void against buyer two if buyer two is a purchaser without notice. Now notice the way these recording statutes always read. They address buyer one, and they say, buyer one, your deed is void under certain circumstances. And the circumstances are if buyer two is a purchaser without notice. Now, some jurisdictions do it a little differently. They say, buyer one, your deed is void against buyer two under certain circumstances, but they have different circumstances. The circumstances in some jurisdictions is buyer two needs to be a purchaser, of course, and they need to be a purchaser without notice, of course, of buyer one, just like before. But some jurisdictions say buyer two must also record before buyer one. And those are the race notice jurisdictions. So in the race notice jurisdictions, buyer one's deed is void against buyer two under certain circumstances, and the circumstances are now three things: no notice, paid money, and recorded first. Finally, there are some jurisdictions that say buyer one, your deed is void against buyer two if buyer two recorded first. Period. They don't require the notice. They got to be a buyer, but if buyer two recorded first, then buyer one loses. And those are the pure race jurisdictions. So we have three kinds of circumstances under which buyer one's deed is void. In the pure notice jurisdictions, buyer one's deed is void if buyer two has notice and is a purchaser. In the race notice, buyer 2 must be a purchaser, have notice, and record first. And in the pure race jurisdictions, buyer 2 just needs to record, be a purchaser, and record first. Now, next comes the issue of what do you mean by notice if the buyer 2 had notice? Well, there are 3 ways that buyer 2 might get notice. One way, buyer 2 may get notice. There are 3 ways for people to, there's actually 2 ways to get notice. And the 2 ways to get notice, I'll put that, don't have a convenient place to put that on the board here. I'll put it on the board right here. So, notice, there are 2 ways to get notice, and these 2 ways are actual notice and constructive notice. Constructive notice means you're going to treat the person like they had notice whether they really got it or not, and there are 2 circumstances where that is true. One is record notice, and the other is inquiry notice. Actual notice means that somebody told you, telephone or something. Constructive notice, either you should have checked the records or you should have gone out to look at the property. Inquiry notice is go look. Now, so these are the ways that a person might get notice. Some jurisdictions say that the second buyer, buyer number 2, so long as the second buyer acts in good faith, they may say good faith without notice. So sometimes the statutes will say good faith without notice. Now, when the statutes do it this way and say that the buyer number 2 is good faith without good faith purchaser, of course. I got to buy. Good faith purchaser without notice, this gets funny interpretation, and this is very important for bar problems purposes. Good faith, this kind of purchaser without notice, here, when they do it this way, it means without record or actual notice. And so when they put it this way, good faith often does not require that you go out and look. Okay? Good faith does not necessarily require that you go out and look. Some jurisdictions, you can see how good faith is a fuzzy boundary. And some jurisdictions say good faith means you got to go look. And other jurisdictions say, no, you don't have to go look. All you have to do is not actually know and check the records. And so this term good faith may or may not include go look, and notice may or may not include inquiry notice. I'll say that again because this is very important. When it says buyer number 2 must be a good faith purchaser without notice, does good faith mean you have to go look? No. It just means you weren't trying to commit fraud. You didn't go out there and look and actually saw it and try to do it anyway. So good faith just means you weren't trying to commit fraud. You don't have to go look. And the notice, this may or may not be included. In most jurisdictions, this is included. Most jurisdiction inquiry notice, you got to go look. And if you don't go look, you're bound by what you would have learned. But there are many jurisdictions where you, not many, there are few, where you don't have to go look. Okay. Now, let me, before we move on, let me show you an example of this, because I need to put the example close to the actual lecture itself, because it helps. In one of the, in two of the problems today, we have this issue. Let's begin by looking at the problem from the February 91 bar. In the February 91 bar, it's about Orrin, Arthur, Bart, and Charles. And in that bar at line 31, it says, State X has the following statutes. Line 31. Every conveyance of real estate, that is, this is a conveyance, every conveyance of real estate, so it went from grantor to buyer number one in our hypo. That's a conveyance. Every conveyance of real estate which is not recorded, okay, is void against any subsequent purchaser or mortgagee. Now, mortgagees count because mortgagees part with money to get that mortgage. So they gave up something, so you got to protect them too. Or a good faith creditor who has acquired an interest for valuable consideration. We'll deal with that part later. And in good faith without notice. Good faith without notice. Good faith could be, given the brief interpretation, you weren't trying to deceive anybody, and without notice might mean just these two kinds of notice. Comes up again in the question from July 02 bar exam. In the July 02 bar exam, in dealing with Baker's Dirt Road, at line 26, the last paragraph, following statutes in force in the jurisdiction. Every conveyance or grant that is not recorded is void against any subsequent good faith purchaser. There you have it again. Good faith, you may or may not have to go out and look. Good faith purchaser or beneficiary under a deed of trust who provides valuable consideration and whose interest is first duly recorded. This is a race notice jurisdiction. You got to record first also. Okay? So in this last one it says every conveyance that's not recorded is void against a later good faith purchaser who records first. Okay. So that's how these read, and we'll look at them in more detail when we deal with the problems. So that completes our discussion here of the recording right here. I'll put this board back up because I realize we just put it up there and people may be copying things off the board, and I'll put that board back up. First, let me circle here just so we're clear where we are. We've completed the recording, and we're now going to talk about adverse possession. So I'll put this back. So we're now going to talk about adverse possession. This will go fairly quickly. Adverse possession is when you can acquire property adverse to the, sorry, get out of the way so you can see it there. There you go. So adverse possession allows people to acquire property without by just taking it. You go there and occupy it long enough, and act like you own it, you end up owning it. The elements of adverse possession are on the board. I'm going to move the board back to those in just a minute in case people have anything else they need to copy here. But you know that the elements of adverse possession is the person must possess the land in a manner which is open, notorious, and visible. That's so that the true owner can realize people are adversely possessing it. So the first requirement is open, notorious, and visible. We know what that means. Secondly, they must be occupying it with a claim of right. They got to be occupying it claiming that they own it. I mean, if you just go occupy some land and you don't claim you own it, you're a trespasser, and that's all. But if you occupy it and you claim it's yours, you're now an adverse possessor. So the open, notorious, and visible claim of right required. I think we can move this board now. Claim of right, right here. Color of title. Color of title is required in some jurisdictions but not others. I'll circle the ones we've covered now. We've already covered open, notorious, and visible. We know what that is. Color of title, we know what that is. Pardon me, claim of right. Color of title. Color of title means that the person must have some document that leads them to believe that they own Blackacre. That gives them the color of title. For example, the person might have thought they got it from a will, but the will was defective for some reason. They thought they got it from a deed, but there was something wrong with the deed and they didn't know about it. So the person has a good faith belief that they own it by way of some document. Now, not all jurisdictions require color of title. The idea behind those jurisdictions that required is that you cannot acquire an automobile by adverse possession. You can't sort of go out there and say, I like that car over there, and if I keep it and drive it long enough, it becomes mine. Well, that doesn't work. And so these jurisdictions are saying, well, why should you let people steal land? If you won't let them steal a car just by keeping it long enough, you don't let them steal land either. And those jurisdictions say you can't acquire ownership without some kind of a good faith belief that it was yours to begin with. Those require color of title, split of the jurisdictions as to whether or not you need. Some say you need it, some you don't. The land obviously must be occupied by, if you're going to adversely possess it, you have to occupy it. Now, this occupying the land is significant because let me suppose that there's a 40-acre parcel of land here and a person occupies one corner, they occupy 1 acre, and they put a fence up and they grow some chickens and raise some horses and stuff on 1 acre out of the 40 acres. And then when the period of the statutory period has run, I didn't put the time down here on this, in other words, you gotta do this for a certain amount of time. I'll just put the word time here, whatever the time requirement is. So, but if you occupy it for the statutory period, you occupy it for the statutory period, at the end of the statutory period, this person gets 1 acre. They don't get 40 acres because that's all they occupied was the 1 acre. But if the person had color of title, if they had a document which in good faith they believed conveyed the entire 40 acres to them, if they believed that, so they have color of title, then when the statutory period is up and they've done everything they're supposed to do, they own the entire 40 acres. So if you get an easement, you get a document that gives you, gives you an easement for 30 feet, a 30-foot wide easement. But there's something wrong, and what happens is that you actually pave a 15-foot easement and you use it for the period of time required to get a prescriptive easement. Prescriptive easement is a easement, just like adverse possession. So you occupy it long enough to get a prescriptive easement, but you have color of title for 30 feet because you thought you had a good title for that. And so when a period is up, you get a 30-foot easement, not just the 15 feet that you used. Occupied hostile. Hostile does not mean angry. It simply means that it was occupied in a manner that was contrary to the rights of the true owner. Contrary to the rights of the true owner. And so we have this one case where the father said to a son that Black Acre is yours. It was a farm. And he said, the farm is yours. I'm too old to run the farm anymore. It's yours. And father moved, in one case, father moved to town and son occupied the land for the statutory period. And then when father died and the other children came forward, there were 4 of them in that problem. And the other 3 children says, we each want 1/4 of Black Acre. And the son said, but father gave it to me. And they said, well, where's the deed? Says, well, I don't have one. He gave it to me orally. Well, you can't convey property orally. So they said, well, since you can't convey it orally, we each want our 1/4. And then he says, the occupying son says, well, I own it by adverse possession. And they said, well, it's true, you were open, notorious, and all that sort of stuff, but you were not occupying it hostilely because father told you you could use it, you could occupy it. So he says, oh, no. Father told me I could occupy it, told me I could have it, in fact, but the key thing is that when I was occupying it, I was telling him and the rest of the world, it's mine. And it wasn't mine because father says to son, it's yours, and that didn't convey anything. But when son then told the world, including father, it's mine, for whatever the statutory periods for 10 years, he told him it's mine, that is occupying hostile to father because he's occupying land, that son is occupying land that son didn't really own, but he's claiming he owns it. And that's what makes it hostile. If you're claiming contrary to the rights of the true owner, that's hostile. And so that's what hostile means. In one case, dealing with this hostile element, father stayed on the land, didn't even move off. Said, son, it's yours. May I stay here for life? Son says, yes, you may stay here for life. Son stayed there for the statutory period, telling the rest of the farmers in the area and everybody in town, including father who was on the land, that Black Acre is mine. Well, that worked. He was there claiming hostile, and father was simply his guest on the land. So hostile does not mean angry. It means contrary to the rights of the true owner. Finally, a minority of jurisdictions require that you pay taxes on the land. Only the western states of the United States require that you pay taxes on the land. And finally, you have to stay for the statutory period, whatever time that is. So that takes care of this entire branch of conveyancing. If you want to convey land, if you want to do it with a deed, the deed needs a granting clause. It needs to identify the land that's being conveyed. It needs to, you need to know what estate you're conveying in the land. You need to deliver the deed. This is where we get the equitable conversion doctrine. I said to you when we dealt with the equitable conversion doctrine that there's only 2 kinds of events that we have to be concerned with for the bar exam. One event is where the person, where the property burns down or is damaged or destroyed, and the other one is where one of the people dies, the grantor or the grantee dies. And if one of the parties dies, the purchaser or the seller dies, the court treats the transaction as though the deed, the grantor still has the deed in hand, and the grantee has promised to pay the money, and the grantee has still got the money in hand. And what the court treats the transaction, if one of them dies, as though the grantor is holding the deed only to be sure that he's going to get paid the purchase price, that the grantor doesn't really own it anymore. The grantee owns the land, and the grantor is just holding on the deed to make sure he gets paid. The grantee really owns it starting as soon as the equitable conversion period begins. So if the grantor dies, the land was already transferred to the grantee, but the grantee hasn't paid yet, so the grantee still has to pay, but the land belongs to the grantee. And likewise, if the grantee dies, the property has already been conveyed to the grantee's estate, and the estate's got to pay for it. So if someone dies, the court's treated under the doctrine of equitable conversion as though the transaction has already taken place, and the grantor is holding the deed merely as a security instrument to assure payment of the purchase price, and the purchase price has to get paid. So that takes care of the delivery. We know what delivery means. We know about the equitable conversion doctrine. We know that there are some covenants of title that can be as many as 5 of them, covenants of title. We know that the deed is the final understanding of the parties. If you don't put any covenants in the title, there aren't any, unless the statute and the jurisdiction gives you a couple. Recording acts, we understand there are 3 types of recording acts: the pure race notice, and the pure notice. And these recording acts address they address buyer number 1, saying, buyer number 1, your deed is void against buyer number 2 under certain circumstances. Let me make one thing clear regarding that, and that is, we go back to our diagram here. The grantor went to buyer number 1, and these statutes say, buyer number 1, your deed is void against buyer number 2 under certain circumstances. Well, the point I came back here to make is that buyer number 1 doesn't really have to be a buyer, okay? They don't have to purchase anything. They can just, it can be a gift. Doesn't matter how buyer number 1 got the land. Okay? This is really grantee number 1. Now these later people down here that we're trying to protect, they need to be real buyers, because they need to part with something. They need to be mortgagees who parted with money. They need to be buyers, somebody who parted with money, and you're trying to keep them from getting ripped off. But these first people, doesn't matter how they got it. It could be a donation, and all the rules would still apply. So we understand about recording acts, and then comes adverse possession. We understand you can convey land by adverse possession, and here are the requirements for it. And there's a split of authority on a couple of these. Let me point those out to you. There's a split of authority on taxes right here, and there's a split of authority on color of title right here, these two. Now, with all that in mind, we now understand if you have Blackacre and you want to convey it, this is how it works. The next thing we want to look at is Blackacre, and instead of conveying all of Blackacre, you want to break it up in terms of people or break it up in terms of time. Okay. Now, we are a little bit short of time, and so I'm going to focus most of our time over here, breaking up in terms of people, because this is much more straightforward. So let's take a look at that. If you want to break up the ownership of Blackacre in terms of people, left one of these off here, prescription. Let's start with easements. If you own Blackacre and you want to convey it an easement in Blackacre, the question becomes, how do you create the easement? What are the rights of the easement holders? How do you terminate the easement? And does it run? Same thing with covenants, landlord-tenant, all this stuff. In fact, what we're going to do at this point, all of these breaking it up in terms of people and breaking it up in terms of time, we're going to lecture on these next week. And what I'm going to do now is to turn to some problems, because we have 3 problems that about the only aspect of this stuff that these problems involve is easements. And so we will deal with easements when we get to it. So this is the one that's included in the problems. It's the only one of this whole set. So we're going to turn to the problems and use everything we've learned, plus we will discuss easements while we do the problems. So let's do that now, so we'll get a chance to wrap up these problems. And we're going to end up running over some tonight, but we're going to run over a few minutes to get some of these problems done tonight. Okay, not that much, but over some. I need to, right. The first problem, February 1998. In the February 98 problem, Don, Stan, Lynn. In 1975, Donna asked her neighbor Stan to give her a roadway easement across his property so Donna could have better access to her own property. Okay, nothing's wrong there. Stan agreed, no problem, and asked Lynn, his lawyer, to prepare a deed, okay, granting an easement for a road 30 feet wide along a designated path. Okay, well, that seems easy enough. There's no real problem yet. The lawyer is supposed to prepare a deed for an easement 30 feet wide along a designated path. Lynn prepared the deed, no problem so far, which Stan signed, no problem so far, and instructed Lynn to give it to Donna. Now, that's where there's a problem. When Stan said to Lynn, here's the deed, give it to Donna, is there a delivery right then? Or does the delivery only happen when Stan gives it to Donna? Because we know from having studied the problem is that Stan's going to die pretty soon. He's going to die before Lynn hands the deed to Donna. Between those 2 events, Stan gave it to Lynn, Lynn has it, Stan died, Lynn gave it to Donna. Now, you see the problem. If Lynn is Stan's agent, if Lynn is Stan's agent saying, give this to Donna, if Lynn is Stan's agent, well, the agency dies when the principal dies. And so if Stan died before Lynn, his agent, gave the deed to Donna, then Lynn can no longer deliver the deed for Stan. The agency is terminated. In that case, Donna did not get a valid deed because the agency had ended. She got a deed and she thought she owned it, but she didn't really get a valid deed because the agency had terminated. Continuing to read, it says, unbeknownst to Stan, Lynn was also Donna's attorney, who had advised her to obtain the easement from Sam. Well, Lynn's got some problems here with professional responsibility, as I'm sure you can recognize, but the fact remains that whether or not Stan has delivered the deed to Donna turns on Stan's intent. And he didn't know, Stan did not know that Lynn was Donna's agent. So that really has nothing to do with Stan's intent. So Stan didn't know that Lynn was Donna's agent. So from Stan's point of view, he intended to give the deed to his own agent, and then he died before the agent delivered it to Donna. And therefore, I think the agency terminated, and Donna did not get a valid deed. Donna thought she did, because she got a piece of paper that looked good to her, and she didn't know that Lynn had done anything wrong. But so Donna thinks she's got a good deed, but in fact, she probably doesn't. Now, one more thing while we're talking about it is that in a situation where a person is the agent of two people and the other person doesn't know about it, if the one person is the agent of the buyer and this person goes out and secretly also becomes the agent of the seller, so unknown to one of the parties, this person is the agent of both. And you can do that if both parties know about it and agree to it. But if one party does not know that, that party has a right to rescind the transaction. Okay? Period. Doesn't matter. It's not a question of rescind it if there was fraud or if it was anything. You just have a right to rescind it if the person was an agent of both parties and one of them didn't know it. So here, that would give Stan the right to rescind because Lynn was the agent of both parties and Stan didn't know it. So in any event, I don't think that Donna has a good title, although she thinks she does. Now, what's going to happen is that Lynn is probably going to end up with a title by adverse possession. Lynn will try to get an easement by prescription. Easement by prescription, she'll say, I got a deed and I thought it was good. I used the land, the easement open notoriously and visibly. I claimed I had a right to it because I thought I owned it. I have color of title because I have a deed which I thought was valid in good faith. I occupied the easement, and I only occupied 15 feet of the easement, as you know from the rest of the problem, even though the deed said 30 feet. But since she has color of title, she's going to get a 30-foot easement when she finally gets it. And I occupied it hostilely, not mad, but contrary to the rights of the servient estate. So she occupied it contrary. You don't have to pay taxes on an easement, so you don't have that problem. And according to the facts, she occupied it for more than 21 years. And no jurisdictions requires more than 21 years because that's a common law rule for adverse possession. A lot of jurisdictions are shorter. California is 5 years. A lot of jurisdictions are 10. Continuing the problem, Stan died that night. Although he was aware of Stan's death, Lynn gave the deed to Donna the next day. And Donna never recorded the deed. Well, you see the problem that Donna probably has. Line 15. In 1976, Donna constructed a gravel road 15 feet wide along the designated path. She's only using 15 feet, but she's got color of title for 30 feet. Donna continued to farm her land and to use the road. So Donna farmed her land and used the road. That's okay. She has repaired the road but not improved it. Okay, she's repaired the road but not improved it, and that's fine. If you have the right to an easement, it's your obligation to keep it repaired, but you don't have to make improvements on it. Part of the reason the bar examiners did not have Donna make improvements on the roads is because you may end up with arguments about easements by estoppel and stuff. They want to do that. So Stan's son, Paul, inherited Stan's farm and has never objected to Donna's activities. Now, we next move to line 19. In 1997, so you can see that this is 22 years later, 1997. So Donna's been there for 22 years, so she's been there for the statutory period, doesn't have to pay taxes, occupied it contrary to the rights of the true owner, did occupy it, has color of title, claimed right, open it, so she's got it by adverse possession, and she's got a 30-foot strip by adverse possession because she has color of title. Line 19, in 1997, Donna announced plans to convert her farm to a commercial complex. She now intends to use the road as the complex's main entrance, widening it to 30 feet. Well, she has a right to 30 feet, as we discussed. Paving it and putting utilities under the pavement. Well, if she's going to pave the easement and put utilities under the pavement, what do we have? Well, line 23 says Paul objects to the road. He says the pavement will interfere with his farming, and they were also told that the area is changing and some farms have converted to commercial use, but Paul wants to keep farming. So the area is changing. So what happens here is that Donna wants to change with the area and Paul doesn't. Can she do it? She's got a right to a 30-foot wide easement, but can she use it in that way? And the answer is that when people create easements and much later the circumstances become different, and the question is, can you use the easement in different ways when that wasn't mentioned in the first easement, in the deed? So here it said, the deed said they're giving Donna to quote you what it says at line 8, it says, we're granting, quote, easement for a road 30 feet wide. So it's easement for a road 30 feet wide. Now, this apparently, they knew that the purpose was so she could get to her land easier, but many years later, things evolve. And now she wants to use it commercially. And when they said an easement for a road, did they mean easement for a road 30 feet wide? Well, it doesn't say a road to her farm or for entrance to her farm. There are no limitations here, just as easement for a road. Can she broaden the use to do what she wants to do? And the answer is that there are three factors that the court will look to in deciding whether or not she can broaden her use. Was it foreseeable that the use may need to be broadened? Was it necessary for her use to be broadened in order to achieve the purpose of the easement? Was it foreseeable? Was it necessary? And how much burden will it impose on the servient estate? Well, if you apply those criteria, the utilities underground, that isn't burdening the farmer at all. Was it foreseeable she may want utilities under the ground? I think so. It's so common. And finally, is it necessary? Well, apparently if she wants to use it for an amusement facility, she needs lights on the road and so forth, and so it may be necessary. So whatever you think about that analysis, that's how you do it. Also, she wants to pave the road. Well, that presents problems. Was it foreseeable she may want to pave the road? Make your argument. Is it necessary for her to pave the road? Well, probably in order for her to use it for what she wants to use it for. And does it burden the servient estate? Well, according to Paul, it will interfere with this farming. And if it will substantially interfere with this farming, it may burden him too much. So the way in which you conclude about the underground pipes and the way you conclude about the pavement is not so important as the fact that you know the three factors that you use to evaluate the situation. And the three factors that you use are, was it foreseeable that this change may be needed? Is the change necessary to achieve the purpose of the easement? And how much of a burden does it impose on the servient estate? And that's how you would analyze that problem. Now, we are going to look at two other problems, but I think before we do that, we have an announcement to make by our producer. Today's class is going to be on two files rather than just one. This file is going to come to an end